The broadcast is now starting. All attendees are in listen-only mode.
Hi, this is Amy O'Hara. I don't know if you heard me before, so I'm going to repeat what I just said. And if you did, it'll only take 2 more minutes of your time. So this is Amy O'Hara. I'm going to be talking about how the Secure Act impacts your retirement accounts. I'm a partner here at Littman Krooks. We focus in the areas of elder law, guardianships, trust and estates, special needs planning and education, as well as corporate work. For more information, please feel free to check out our website at littmankrooks.com. There is a dialog box where you could ask questions. I will not be looking at these until the end of the presentation, so just know if you type something in there, I'm not going to get it until the end, and then hopefully I will see it and I'll be able to answer it for you. So there we go. So what is the Secure Act? The Secure Act is setting every community up for Retirement Enhancement Act. It was signed into law in December 20th, on December 20th, 2019, and became effective as of January 1st of this year, and impacts also individuals who died on or after January 1st. It's the first major update to retirement asset rules in many, many years. And it is making changes, significant changes to the tax rules on retirement accounts. I'm going to, and when I'm talking about mainly today are tax deferred retirement accounts, I will mention a Roth here and there, and I will mainly be focusing on IRAs. Certainly 401ks and 403bs, which are employer-sponsored plans, are factored in here, but they're typically rolled over into a traditional IRA at some point. So I will be focusing mainly on traditional IRAs in terms of terminology. So, why does this all matter? Oftentimes I see clients and their two biggest assets are their tax-deferred retirement accounts and their home. And so our tax-deferred retirement accounts is really tax-deferred. And so a $500,000 IRA is not really worth $500,000 when you consider the taxes that are due on the withdrawals of those accounts when you have to start taking distributions. The primary benefit of an IRA has always been the tax-deferred growth. It benefits you while you own it, and it also benefited your heirs or your beneficiaries after your death when they inherited the account. So pre-Secure Act, so before 2020, we were all required to take our required minimum distributions. Sometimes we refer to them as RMDs or MRDs, starting at age 70 and a half. And then upon your death, the balance of your IRA went to designated beneficiaries, assuming that you properly named them, and that was spread out or stretched out over the beneficiary's life expectancy. So we were able to continue the tax-deferred payment. And the other thing is that if the estate was named, if your estate was named, or there was no designated beneficiary, the inheritor took the payout over 5 years or your life expectancy. And what basically that means that if you owned an IRA and you did not name a beneficiary on it or properly name one, or you named your estate and you died before you had to start taking your required distributions, then your beneficiaries or the estate had to take out the IRA within 5 years. If you were already taking your required distributions, then the account owner, the new beneficiary, would take it out over your life expectancy, but they weren't able to stretch it out over their life expectancy. That same rule that I just mentioned right here on this third bullet point is still in place today under the new rules. So I will not be focusing on this, but under the Secure Act, this rule is still the same. Similarly, the same rule that a spouse beneficiary is excluded mainly under these new rules, and they could also roll it over into a spousal IRA. So Secure Act 2020. Some good things and some things that we have to plan for. A good thing is that now you could actually wait to take your required minimum distribution until you're 72 years old. You don't have to start taking them at age 70 and a half, And later this year, the IRS is expected to issue new life expectancy tables on how to calculate the required distribution starting at age 72. You can also continue making contributions to your IRA if you're still working, regardless of your age. Previously, you weren't able to do that, so that now you can. Now, a big significant change is upon your death, the option that I just mentioned before, where the beneficiary can stretch the inherited IRA over their lifetime, is virtually eliminated for most beneficiaries. There are some exclusions, which I'll focus on later, but for most beneficiaries, we don't have that option any longer. And that the beneficiary must withdraw the entire IRA within 10 years of your death. So that's going to cause some, again, we're talking about tax deferred assets here, so it's going to cause an acceleration of that tax due. Now, some certain excluded beneficiaries, I may refer to them as excluded or exempt, but there's 5 types of beneficiaries who can still take distributions over more than 10 years or their life expectancy. Serving a surviving spouse, which I mentioned before, they could take out the IRA upon your death over their life expectancy. They're not going to be subject to withdrawing it within 10 years. Minor children, so that 10 years does kick in once they reach the age of majority, which is 18 or 21, depending on the state. But then the 10 years starts, but they get that deferral while they're still a minor. This does not apply to grandchildren. So I know I have some clients from time to time that want to leave their retirement accounts and name their grandchildren. First of all, for other reasons, we don't want to name minor grandchildren as beneficiaries. But that issue aside, you don't get this exclusion for grandchildren. Disabled beneficiaries are excluded. So an individual is considered to be disabled if he's unable to engage in any substantial gainful activity by reason of any medically determined physical or mental impairment, which can be expected to result in long continued or basically indefinite duration. Chronically ill individuals. So an individual is considered chronically ill if they're unable to perform at least 2 activities of daily living, which include eating, toileting, transferring, bathing, dressing, incontinence, and that they have a significant impairment in terms of cognitive impairment, or excuse me, it's an or. So they may not be lacking in any activities of daily living, but they may have a severe cognitive impairment, which may threaten their health or safety. So they are characterized as chronically ill, and we're able to get, for disabled individuals or individuals with disabilities and individuals who are chronically ill, the IRA can be quote unquote stretched, even though we're really not using that term any longer, over their life expectancy. Withdrawals can be made over their life expectancy. And also, this is not a good thing, but is that if the beneficiary is less than 10 years younger than the owner, the account owner, then they would take it out over their life expectancy. So if the beneficiary is, let's say, only 5 years or 6 years younger than the account owner, then they have to take it out over their life expectancy. So implications of the Secure Act, just a kind of a little bit of a recap so far, is that some good things that came out of this new act is that we get 2 years of extra years of tax deferred growth, and that we don't have to take distributions until age 72 now, and we can continue making contributions to our IRAs if we're still working. We have some not so positive attributes to this new law, is that we're no longer able to do that lifetime stretch. And now it's turned into a 10-year rule for most beneficiaries, which increases the tax on distributions. And I'll use an example in a moment, but it may bump up the beneficiary into a higher income tax bracket as a result of those distributions. And you're going to see an overall depletion of that IRA account in a very short time period. You won't be able to continue it over the beneficiary's life expectancy. So here I'm going to give you a little bit of an example of how inherited IRAs work pre-Secure Act and post-Secure Act. So for purposes of my example, let's assume that we're dealing with $1 million IRA at the death of the owner, and the owner names his adult child as beneficiary, 100% beneficiary. The beneficiary is not excluded, has no disabilities, or does not meet any of those other rules. The adult child beneficiary is 44 years old, and we're going to assume a 6% growth rate. So under the old rule, if this 44-year-old individual inherits the IRA, they, over the existing or the previous life expectancy tables, their average annual, and these figures are estimated, but over the first 10 years, they would take out about $33,000 a year. And over that 10-year period, not subject to inflation or interest or growth, but it works out to be about $331,000 that they would take out of that $1 million IRA. At the end of the 10 years, because that IRA is continuing to grow, depending on the here it's on a 6% inflation, it's valued at, $1.3 million, greater than $1.3 million. And that tax deferred growth, if that 44-year-old beneficiary lived until he was 83 years old, we're looking at that value of that account that would be distributed to the beneficiaries over $4 million. That's quite significant here under our old rules. Under the new rules, however, the beneficiary is required to take the distribution within 10 years. Okay, they could take it all in 1 year, or they could take out a percentage each year. So here, let's just assume that the beneficiary takes the annual distribution of $131,000 over 10 years, that they would ultimately be taking $1.3 million, and they're going to lose out on over $2.8 million of growth and distributions that's stretched out over that 44-year-old's life expectancy. And also that $131,000 a year that they may take out could possibly increase them, bump them up to a higher income tax bracket, so that if they were, based upon their other income and wages, if they were at a 24% bracket, it could put them up to a 35% income tax bracket, or going from a 32% up to a 37% income tax bracket. And that's where it's careful planning needs to happen when beneficiaries inherit this IRA as to when is that best year or years to take the withdrawal of the IRA. Do we do it all in 1 year? Do we stretch it out over 10 years, or take distributions out over 10 years? And some tax planning is important to happen there, as well as working with a financial advisor that could kind of quote unquote run these numbers to see what works best for you, and a tax advisor. So just a little bit of a recap from where we are right now. Remember, certain IRA beneficiaries retain, that lifetime payout option, which are surviving spouses, individuals with disabilities, and individuals who have chronic illness. The other beneficiaries, the 10-year rule applies. So we want to review existing trusts, which name beneficiary, to make sure that they are compliant under the new rules. We'll want to reconsider planning for our spendthrift beneficiaries who just, burn money through their pocket and can't retain it. And we want to explore what options are available with working with clients now to replace any tax loss for that payment of that income tax. So I'm going to review under our so whenever we consider naming a trust as a beneficiary of a retirement account, we as practitioners will consider conduit trusts or accumulation trusts. And so I'm just going to give you a little bit of synopsis of each one, because what made sense under the old rules may not necessarily make sense now. And so this is where it's important for everybody to review their estate plans, especially if they name trusts as beneficiaries, because unintentional consequences may happen. So under a conduit trust, all distributions from the retirement account to the trust must be distributed out to the beneficiary more or less immediately. If the beneficiary is not in the excluded class, which I mentioned before, if they had a disability or they were surviving spouse, or they're a minor child, then that 10-year rule is going to apply. And the conduit beneficiary will receive outright distribution of 100% of the benefits within that 10 years of the account owner's death. So whether it's all taken out over 1 year, over 10 years, however it is, it's all going to be net any expenses or taxes. It's going to be distributed out to that beneficiary. Okay. The distributions, the income tax is going to be paid by the beneficiary from that money. You're going to be looking at their income tax, the beneficiary's own income tax brackets. And so analysis will have to happen as to whether it's taken out all in 1 year, or it's deferred for 10 years or 9 years, or it's equal distributions are made out. This type of plan is not helpful for our beneficiaries who have spending issues, or if we're concerned about any type of marital claims or protection of assets from that perspective. Another option as an estate planner, what I look at are accumulation trusts. And so if we are naming a trust as beneficiary of a retirement account, we are oftentimes going to look at these accumulation trusts more often than what we may have in the past, from the way that they work. So with an accumulation trust, the trustee can actually accumulate the retirement distributions in the trust during the lifetime of the beneficiary and distribute the assets out as needed or in the trustee's discretion. Similar to a conduit trust, if the beneficiary is not within those excluded classes, then the 10-year rule does apply. But again, there is no immediate distribution outright to the beneficiary, but rather it can be accumulated in the trust. And so the trustee can elect the strategy as to what distributions, when to make distributions to the beneficiary, how to do that, whether you defer it until the next generation or to the remainder beneficiaries. And that also the governing trust instrument, that the trust agreement is going to also kind of write the rules for how the trustee can administer that. One thing though is that the tax rate we're looking at typically with these type of trusts is that they're subject to a higher tax. That the tax brackets are condensed so that once the trust earns close to $13,000 of income, we're paying a 37% income tax. And so that's, just to repeat that, so once the trust earns close to $13,000 of income, and this is not a new rule, this is something that, it changes a little bit each year for inflation, but we're at that top tax bracket, whereas an individual does not hit that 37% tax until they earn over they have over $500,000 worth of income. So we are looking at a condensed tax bracket, so 37%. But on the other hand, this is very helpful if we have beneficiaries who are spendthrifts or who have disabilities and we want to preserve for government benefits, which I'm going to talk about probably in my next slide here. So with supplemental needs trusts, we're able to, so we would be looking at this accumulation trust, okay, so that we could accumulate the assets, and that the assets, it's critical that we don't have that conduit requirement where the IRA has to be distributed out to the beneficiary, because although today's topic is not really focused on supplemental needs trusts, but for those who have family members who are inheriting and need to rely on government assistance, such as Medicaid or certain social services programs, there's typically asset and income tests. And the way that supplemental needs trusts are structured is that the assets in the trust are exempt and excluded from counting as the beneficiary's assets and income. And if the supplemental needs trust has conduit provisions, then we have that pass through. So that beneficiary is going to get that income and then probably have too much in assets, and which will jeopardize oftentimes very much needed government benefits. And so we want that accumulation. We want to structure our supplemental needs trust as accumulation trusts. And we're able to avoid that 10-year rule as long as the beneficiary meets those definitions of disabled or chronically ill, which are set forth in the IRS rules and regulations. Now, it's important to note that the beneficiary status as disabled or chronically ill is determined as of the date of the account owner's death. Okay, so which means that if the beneficiary becomes disabled later in life or becomes chronically ill later in life, we're not going to be able to take advantage of this, of this life expectancy, stretching out over the life expectancy, and we will be subject to the 10-year rule. With our supplemental needs trust, we want to be careful not to have multiple beneficiaries. It could just muddy the way that the 10-year rule works and the delay of the distributions. It's okay, however, for the trust remainder to have multiple beneficiaries. So, for example, is you leave your child, Leslie has a disability, and we're leaving a percentage of your retirement account to Leslie's supplemental needs trust, and she's the sole beneficiary of that trust for her lifetime. And at her death, the trust says, I leave everything to Leslie's children, or if she doesn't have children, then you leave it to your children. You could have 3 children, 3 other children, and that's not going to muddy the issue in terms of this life expectancy payout. Except the one caution is that we want to be careful about naming charities, because charities do not have life expectancies. And right now we're still using the IRS existing regulations. There's no regulations out, and so there could be an acceleration of that distribution and not the payout over the life expectancy if we have a charitable remainderment of a supplemental needs trust where we have the trust as the beneficiary of a retirement account. So in those cases, sometimes what we do is we'll consider more than one special needs trust. So I have clients that are charitably inclined. We may do 2 special supplemental needs trusts, one for the retirement account, the IRA money, and one for other assets. When the other assets trust, we can name charities as remainder beneficiaries. Just some other planning options here, and this has probably been, all over the mainstream media about considering Roth conversions at this time. And now it probably makes sense to consider more so than ever. So when you convert a traditional IRA, and for the most part, as I mentioned in the beginning, I've been talking about traditional IRAs, tax deferred, assets here where you have not paid income tax on them. But you roll over assets from a traditional IRA into a Roth. And when you make this conversion, you're going to pay the taxes at that point of that rollover. But when whatever is the net of that is going to go into the Roth IRA, and it's going to grow tax-free. And with Roth IRAs during the account owner's lifetime, you don't have required distributions. So you could continue to grow the assets in that Roth tax-free. And you could even, upon your death, name your spouse, and that could continue. That your spouse doesn't, because remember, your spouse is not subject to that 10-year rule. So your spouse can also delay and not take any distributions from that, and that could continue to grow. And then when both of you are deceased, or if you name your children outright, or your spouse names your children, your surviving spouse, your children, assuming that they're not excluded under those prior examples, they have to take it out over 10, within 10 years. But all of what they withdraw, it's all tax-free because you've already paid the tax at the initiation of when you funded that account. So that lends itself to some really good planning and considerations there to think about that. Another idea is to look at life insurance, to purchase life insurance to offset any of this significant income tax hit that may occur. You want to consider possibly, having this life insurance in some type of irrevocable trust so it remains outside of your estate for estate tax purposes. But it certainly is something, a vehicle that can be used to help offset some income taxes. Another idea is to consider charitable trusts. If you're charitably inclined, consider like a charitable remainder trust. In this type of trust, is an irrevocable trust that distributes a percentage of the trust assets to your beneficiaries over their lifetime. And at the end of the beneficiary's life, or if you set a term, it doesn't have to be, you could set it like for a 20-year term, the trust terminates and the balance of the assets are paid to the charity. So just a couple different ideas, for consideration. Now this discussion, that I've talked about today is really just a brief summary of a lot of the main provisions of the Secure Act. If you own retirement accounts and you've had your estate planning done, recently or prior to, 2020, it's worthwhile to have it reviewed, especially if you name a trust as a beneficiary of any retirement account, because you want to make sure that it still works under these new rules. So thank you so much for attending today. I'm just seeing if there's any questions that come through. Hold on, bear with me. Okay, how can you prove that a beneficiary is chronically ill so that they could get the lifetime instead of the 10 years? So under the IRS, the law, you typically need some type of certification from a licensed healthcare practitioner. There's a certification that could characterize them as chronically ill, and so that should be sufficient, is having that certification. Where, and again, to repeat that, is that an individual qualifies as chronically ill in order to get that lifetime payout if they're unable to perform at least 2 activities of daily living for at least 90 days, if they meet that disability definition, or they have significant or severe cognitive impairment where their health and safety can be jeopardized. What if your beneficiary is disabled but has a supplemental needs trust and the beneficiary is the trust rather than the individual? So just to clarify, you do want the trust. You don't. So if we have a beneficiary that we want to inherit who has a disability and cannot inherit that IRA outright, we do want to name the supplemental needs trust as the beneficiary. And as long as that trust is set up properly and kind of quote unquote checks all the boxes, then it should be exempt, and that beneficiary does meet the definition of disabled, then you should be able to, you will be able to get that distribution out over the life expectancy of the beneficiary. So is the 70.5 RMD requirement changed to 72 years for 401ks? Yes, it is. Oftentimes, when individuals retire, though, they're going to roll their 401k over to a IRA, because you'll just have so much more control, and you're not going to be subject to the employer's plan document, and you'll just have a lot more options in terms of investments and lower fees, and other incentives that most times your 401k will be rolled over to an IRA. But you do get that 70. That required distribution requirement does apply to 401ks. That it's 72 now. Well, thank you very much for joining. There's no more questions, and I appreciate you joining me today. If you missed any part of this presentation, I know our firm will be uploading it on our website and probably to YouTube, so you could feel free to listen to it again, or if you missed anything, by all means, do that. Just give us a few days. Thank you so much, and I appreciate your time.